Hi, this is Madison Elder. I'm here in the Bloomberg Law Studio here in Washington, D.C. I'm joined by Chris Condalucci, who is the principal and sole shareholder of CC Law and Policy. Chris, good to have you here today.
Thanks for having me.
So today we're going to talk a little bit about that recent expansion of association health plans that the Labor Department just did. For those of you who are just joining us, association health plans are essentially a small business group healthcare option. And now, Chris, you have started a coalition of small business groups and employers who really want to support this rule and use these plans. Can you tell us a little bit about that coalition?
Yeah, the coalition is made up of organizations wanting to establish association health plans or organizations that already are. And we want to work constructively and collaboratively with the states. We really have two primary goals. One is to work with the states to have the states recognize the flexibility that is set forth in the final regulations. And the second priority is working with the states to help them root out any fraudulent activity, any fraudulent actors. We, as an organization, want to offer comprehensive coverage to the members of the respective organizations that are part of the coalition, and we want to communicate that to the states. And that is our primary goal, as well as trying to root out fraudulent actors.
And so what does some of your work look like so far?
We have sent a letter to the State of Pennsylvania Insurance Commissioner asking them to clarify a particular legal rule and how the Pennsylvania Insurance Department is going to treat these organizations sponsoring an association health plan. In short, Pennsylvania indicated that even though these groups of small employers as well as sole proprietors would band together and under the final rules offer a large employer plan, the state of Pennsylvania has indicated that they're not going to respect the large employer plan status. Instead, they're going to treat each small employer as a small group and each individual sole proprietor as an individual.
So that's something that the DOL clarified under the rule, was that states retain their ability to regulate these plans. What have some other states done? What has the reaction been like?
I separate the states into two different buckets. We have what I'll refer to as, let's say, hostile states or anti-federal regulation states, and the other bucket is friendly states. So we talked a little bit about the anti-AHP states. There are some friendly states out there. Louisiana, in particular, issued a bulletin. Their insurance department issued a bulletin that specifically said, we're going to respect this bona fide group or association of employers definition, and we're also going to follow the new rules, which really means any organization of small employers and sole proprietors that wants to offer an association health plan in the state of Louisiana would be treated as a large employer plan. Iowa similarly has issued regulations saying something to the same effect as Louisiana, as well as Illinois, as well as Michigan. We have some other states that haven't issued bulletins per se, friendly states that haven't issued bulletins per se, but have shown that they are open to allowing this large group status to organizations. For example, Nebraska, recognizing the Farm Bureau, the Nebraska Farm Bureau, as offering a large employer plan to self-employed farmers. Nevada is also allowing their local chambers to band together to offer a large employer plan. So we're seeing some friendly states in addition to some of the hostile states.
All right. And so another reaction to the rule that really made headlines was the lawsuit that 12 attorneys general filed against the Labor Department, saying that the rule violated existing law. So can you tell me a little bit about what you made of that lawsuit and where you think that might go?
Yeah, and first, the lawsuit just adds another layer of complexity to an already complex issue area, and it just adds to the uncertainty of the legal landscape. Essentially, the 12 attorneys general are stating that the federal rule should be invalidated. But what's interesting here is that final regulations have the force of law, and states and private stakeholders are supposed to follow the law until a court tells you otherwise. Now we're waiting for the court to tell us one way or another, but unfortunately there are some states that in the meantime are simply saying, we're not going to follow the federal rules. So it's questionable as to whether the legal challenge will prevail. There's certainly arguments on both sides and good arguments on both sides, and only time will tell whether the rules are invalidated. If I were to venture to guess, I think the court will uphold the law. I do believe the Department of Labor did have the authority to issue the rules. The attorneys general are contending that the federal rules conflict with the Affordable Care Act. I have some issues associated with that legal challenge, but the court at the end of the day will decide, and we'll see whether that's going to smooth out the legal landscape or whether the Department of Labor is going to have to go back to the drawing board.
All right, great. Well, that's all the time we have today. Chris, thank you so much for joining us, and thanks for watching.
Thanks.